Hello, everyone. Welcome to the Multnomah County Diversity, Equity, and Inclusion Committee's discussion on providing court services to people who are elderly or disabled. For those of you who don't know me, my name is Morgan Long. I use pronouns she, her, hers, and I'm one of the judges here in Multnomah County. This Lunch and Learn session is being recorded. The recorded session will be available to OJD judges and staff later. Please be sure to look for the recorded session for this and all of our past presentations on our Diversity, Equity, and Inclusion SharePoint page.
Cool.
If you have questions during this session, please feel free to post them into the Q&A feature and they will be addressed. You can find the Q&A feature by going to the very bottom of your WebEx screen, go all the way to the right to the little 3 dots next to the chat, and it will give you the option to click into the Q&A. At the end of today's session, Roger will post a link to a feedback survey in the chat. Please be sure to take a moment to provide feedback for both the presenters and the DEI committee. CLE credit is available for this session, so if you're an attorney and would like CLE credit, please type your full name and bar number in the chat now, and we'll pass that information along to the bar. Our flyer for today's presentation has a lot of information, biographical information about our presenters, so I won't take too much time away, but I do want to introduce the Honorable Patrick Henry, who is one of our judges here in Multnomah County Circuit Court on the Family Law Bench, and he is our Chief Probate Judge. Our other presenter is Mark Sanford, who is manager of the Office of Multnomah County Public Guardian and Conservator. They both have a wealth of knowledge, and so I'm going to stop talking so that we can hear all of their fantastic information. So please take it away. Thank you.
All right. So good afternoon, all. As Judge Long said, I'm Judge Henry. My pronouns are he and him, and I'm part of the Family Law Bench. Before I joined the bench, I worked at the county attorney's office, and my main assignment was to be the attorney for the County Human Services Department that included the Public Guardian's Office. And in Multnomah County, we're very, very fortunate to have a Public Guardian's Office. Mark's going to talk more about where his office fits into the overall system of care, but I've got to tell you how fortunate we are in Multnomah County that there is his office and that we have such a capable person in Mark Sanford as our public guardian. The Public Guardian's Office not only is involved in dealing with some of the most difficult cases involving vulnerable adults. They're often conferred with, talked to about difficult cases by people who are in the system of care to try to develop plans to avoid people being subject to a guardianship and to try to address plans and resources that can help people maintain their independence. Mark, I thought of when Judge Long approached me about doing a talk in this area. I thought of Mark immediately because Mark has been working so many years in this system of care, trying to address issues relating to people who are elderly and disabled. So I'm really happy that he was willing and available to join us today. Overall, the thing that I guess I want to have people understand as some takeaways is hopefully we'll be addressing issues that will be helpful to you, to folks who work in the courthouse, in serving people who are coming to us with issues, with challenges, and are seeking to have cases heard and cases resolved in the courthouse. And so what we're going to do is talk just generally about some of the challenges that are facing seniors right now as a general issue, some specific challenges that seniors face as they come into the courthouse to try to get services. I'll talk briefly about the legal framework surrounding the delivery of services, but I'm not going to spend too much time on that. And I'll talk a little bit about why that is when I get to that slide. Mark's going to help illustrate what the system of care looks like for people who are elderly and disabled in our community. and he's going to provide some helpful insights into how a non-expert, like all of us, can evaluate an adult's functioning to determine whether or not some additional supports are necessary to help that person engage fully in the courthouse. And another issue that he's going to address is how, if we see a person may not be functioning at the highest level, can we communicate? How can we interact in a way that is helpful with people who are having some cognitive challenges in addressing whatever it is they've come to the courthouse to address? And finally, we'll talk briefly at the end about working towards a trauma-informed approach to providing services to vulnerable adults. So that's the plan today in terms of the subjects that we are planning to cover. You know, as a background, one of the things that has been talked about now for many years is how the baby boom generation, that is the cohort that was born between 1946 and 1964, was a huge boom in the population in the United States during that period. What would happen to the systems as that baby boom generation aged and created this sort of tidal wave of needs in the community. So the first baby boomer turned 70 in 2016. And the last baby boomer will turn 70 in 2034. So in that 18-year window, we're about a third into the crashing of this wave of a giant population of people who are elderly. And currently, well, not currently, but in 2020, the U.S. Census indicated that the estimate was that there are over 50 million people in the United States over the age of 65, and that by 2030, 1 out of every 5 Americans will be in the elderly population. So the issues relating to elderly people, their need for services, is only going to grow. As I said, we're about a third of the way into this population tidal wave, where we should expect to see an increase in the need for services in the courthouse from an elderly population. There's a 2009 study that I found that helps illustrate what happens in this age cohort in that as they enter that period between 70 and 79. Over an 8-year period, the study found that 30% of the people in that age group maintain their cognitive functioning. So a third of the people approximately had no significant change in their cognitive functioning, but 53% experienced some loss of function, and 16% had major cognitive declines. So that, the overall numbers, I guess you could say, are, that elderly people on the main maintain cognitive functioning well into their, even into their 80s. But there is a segment of people in that age cohort whose functioning is going to decline. And the numbers that we should expect to see will only increase over the coming years. So that's a background to the community of people that we're serving. And the community of people that we're talking about, those who are reached their retirement years, the challenges can be very significant if they don't have the kinds of social and economic supports, and as they age become isolated. So you may see, for instance, people in this population group right now are experiencing a great deal of economic stress. With a high level of inflation, people on fixed income can be expected to be experiencing significant financial stresses. That's important to us in the courthouse because that can mean that people have limited access, for instance, to resources to be represented by attorneys. And the people who are coming to court who are not represented by attorneys, it's a very significant part of the population of people who are trying to access the services here. So I think I should emphasize that as I was imagining the people who would be most vulnerable, who are going to be most in need of our solicitousness and concern here in the courthouse, are people who are unrepresented and are kind of relying on their own devices or their own natural supports in order to obtain services in the courthouse. So that means that I'm talking generally or thinking mostly about cases that are civil in nature, like landlord-tenant cases, restraining order cases, domestic relations cases, those kinds of things where small claims, where people are generally speaking, 75% or so of our domestic relations cases, for instance, people represent themselves. So we're talking about people who are now going to rely on courthouse staff, clerks, and judges to be able to manage within the system here that we have to try to have their cases heard and to have an ability to be heard in relation to whatever it is the issue is that they're addressing here. So economic stressors are going to be significant with this population. As I indicated earlier, we have an expectation that people are going to have some level of cognitive and physical limitations in decline as they age. I think it's important to emphasize the medical vulnerabilities that people face. As we know, the population of people who are 65 and older are much more vulnerable to the impacts of the COVID pandemic. And how does a court respond to people who have that level of medical vulnerabilities? I mean, I would say that one way that we're currently responding through our presiding judge is continuing a requirement that people in public areas in the courthouse keep masks. Even though in other areas of the world, in other areas where people go, they can be in places where they're able to be mask-free. In my mind, it is a way of being responsive to an elderly community, to a medically vulnerable community, to maintain some additional protections, because people who are coming to court aren't choosing necessarily to come here. They're required to do so, either as part of jury duty or as part of having to get a case filed or make an appearance in a particular proceeding. So it's, I think, an important lens to be considering. How do we have people feel comfortable coming to court if they're medically vulnerable? And that would, to me, would be an example of that kind of response. People who are in this cohort, in this community of people who are aging, we can see in this cohort, in this population, a great deal of social and physical isolation. Communities no longer have extended family all living in the same location. As children age, they move away. As people age, their loved ones may pass away, and it could leave them in a situation where they're socially and physically isolated. And I think those are all very important factors to be considering when we're meeting and addressing people who may have some cognitive or physical limitations in the courthouse. So moving then from a wider community of considerations regarding people who are elderly and challenges they face, there are specific challenges, obviously, when an elderly person with cognitive and physical limitations is coming to court that people face when they're coming to the courthouse. The first point I want to emphasize, though, is how much this space has improved for elderly disabled people. That is, the new courthouse versus the old. There was a great deal of thought and planning and actually conversations. I think Mark would agree that there was an engagement with the people who are designing and building this courthouse to make it more accessible, to make it more inviting to people with physical and cognitive limitations. When you come into this courthouse, it's much more open, there's much more light, there's much less chaos in a small space that people used to have to move through in that small lobby we had in the old courthouse. There's really a great deal of improvements in terms of how the courthouse, the physical layout of the courthouse itself is improved. Picture what it was like for an elderly person previously to have to get some documents in room 210 from that narrow hallway with limited seating where people had to wait online. None of that is the case anymore. People can come in, they get to the second floor, they get a number, they can remain seated until they're invited to come to a desk. And from that point on, staff are actually trained to assist people to go to the next step that they need to take. And one of the things I did in preparation for this conversation today is I did that tour myself. I actually wanted to see firsthand view of what it was like if I'm coming into the courthouse, and what I did as a test case was I wanted to get an elder abuse restraining order and what that process looked like. And staff walked me through it. And literally, if I was here to get that restraining order and I was having difficulty understanding where to go next once I was handed the paperwork, or where I was to go once I was directed to go to down the hallway, over to the crane room, there are desks there to fill it out, or up to the fourth floor, there's an office there where there are people waiting to help you complete your restraining order application. To the extent I would have difficulty following through with those steps that I just suggested would need to be taken, the staff will actually take me physically from the second floor room to where it is I need to go next if I'm showing signs of needing that assistance. I think that's I was just very impressed with how well staff is trained and how well we are set up to address the needs of elderly people who are coming into the courthouse, at least as to this first step. So I did want to emphasize that up front, that we're doing awfully well. That's not to say we can't improve, and we're going to be very open to having a conversation about things we could do differently to improve the experience of vulnerable people coming into the courthouse. But there's a lot we're doing right, as far as I'm concerned. So some of the specific challenges: how do I get, where do I go next? How do I get to the right place and get there in the right time? Thing is scheduled to start at 9 a.m. I just had to wait in a long line to get into the courthouse, and I'm not going to be able to run to the. So hopefully I have a judge that I'll be facing at 9 a.m. who will understand that it may have taken me a few minutes more to get to the courtroom. I'm going to have to complete some pleadings. I'm going to have to do case-specific paperwork. I mean, that's going to involve a lot of executive functioning and problem solving. People who have some cognitive limitations, when they're in a noisy environment, like where there's a large docket, are going to be really challenged understanding all of the moving parts, everything that's happening while cases are being called. Lawyers are reporting out, other parties are reporting out whether they're ready or not. It is a confusing environment to be in that I think we should be aware of how that could impact somebody with a cognitive or physical impairment who are in that kind of confusing, loud environment. And then finally, the thing that all of us are very cognizant of is, how do we help people understand what's going on in a particular case when a case is before one of us judges, or in the courtroom, clerk, staff, others. How do we help people understand what's happening, and how do we take steps to help people participate fully in what's happening in the courtroom? So this is two areas that I just wanted to highlight, because when people hear about this subject, providing services to disabled and elderly people, there are a couple of things that immediately come to mind. Excuse me one moment. One is the Americans with Disabilities Act. And this is not an area that I'm going to go into in any detail today, other than to say that, in effect, there's a federal statute that says if somebody has a disability, then the entity that's providing services needs to enter into a conversation with that person about how and what ways they need assistance to be able to fully participate. It's an obligation under the law that we have. And the conversation begins by the person telling the court what it is that they need as far as assistance. And that process is laid out very clearly in the court's webpage. And I've got a link to that page that'll, if you look on the home page, Accessing Court Services, there's a link here. It'll lead a person to a form that they can complete to express, here's what I need to access services. So that's, I think, very helpful that it's very much upfront and very much on our on the court's webpage that people can see very prominently. And the conversation director, in a way, is Jeremy Wolf on behalf of the court, who will actually engage people when they're asking for services or supports in accessing services here in the courthouse. So that's all I'm going to say about the ADA. We do have an ongoing obligation to respond to people's requests for reasonable accommodations, and that's what that conversation is all about. What is it that people need to be able to access services, and the accommodation that the court can provide that would be reasonable to address that their ability to access the service. A second statute that people oftentimes think about when we have a conversation about elderly and disabled people is the Elderly and Disabled Persons Abuse Reporting requirement. I will say that it's, in my mind, can be somewhat distracting to think about our mandatory reporting obligations when we're talking about having or addressing people's need for assistance in the courthouse. It shouldn't be important if somebody is vulnerable and is in need of some services. As far as our response to them, it shouldn't be important that I am thinking, well, if I don't do what's appropriate, I could get in trouble. That's really what the mandatory reporting law is all about, right? It's a system to identify people who have regular contact with the community, like lawyers and doctors and judges, who are made mandatory reporters, that they're being directed. If you see somebody who may be subject to abuse or neglect, then by all means make a call and get them help. I find the conversations about the mandatory reporting law to not be helpful because we tend to focus on what the specific definition is of abuse or neglect. My hope is that you'll come away from the remarks that Mark will be making in a couple minutes with an understanding that you don't have to worry about whether somebody is actually subject to abuse or neglect to make a referral for them to services that might be helpful to them. So focusing on abuse and neglect, I think, in certain ways is kind of off point. What hopefully, my invitation is, if you see somebody who looks like they need some services or support, there are resources in our community that Mark's going to talk about that we can reach out to get those services and support. So I'm not going to go into a great more detail about the mandatory reporting law, other than to say there is a mandatory reporting law, but the more important point is that there's a system of care that a person who you identify in your interactions with people in the courthouse as needing some additional supports, some services, there are ways to make referrals to the system of care. The other problem I see with the mandatory reporting law is people feel like, well, if I'm not a mandatory reporter and it's not a mandatory report situation, then perhaps I'm not permitted to make a referral. I have to either fall within a category of people who are allowed to make a referral, or it has to be a situation in which I'm allowed to make a referral. Again, neither of those things is true. You can, just as a member of the community with a concern about the well-being of an elderly or vulnerable person, make a call and seek the assistance of the people at the county who operate the system of care. And so in order to understand what those resources look like, I'm going to ask Mark to provide some more detail about the county's role as an area agency on aging and the county's role in the adult protective system.
Thank you, Judge Henry. I am Mark Sanford. I use he, him pronouns, and I am a manager of the Public Guardian and Conservator's Office. Also a member of the leadership team for Aging, Disability, and Veterans Services Division here within the county. And I'm really happy to be here with you all today. When Judge Henry asked me to join him as a community partner of the court to provide some information on the protective system for older adults and people with disabilities, including vulnerable adults here in Multnomah County, and to assist court staff with some information that will hopefully support you in your work with this population. I know people are here in various roles and have different interface with the court, but all I'm assuming are here for the same goal, to improve courthouse experience for vulnerable folks. So when Judge Henry called me the other day, my first thought was that I should recuse myself, as he does for our cases, having formerly been our county attorney, but I opted to say yes and participate today. Although I've worked in this area for over 30 years, I've actually been here at the Public Guardian's Office in various roles for most of that time, and have been managing the office for about the last 15 years. So I have some expertise in certain areas. Certainly don't consider myself an expert when it comes to working with vulnerable people, but I hope I can share some insights based on my experience. I'm also fairly certain that there's a tremendous amount of expertise in the audience today, and so hopefully you'll have an opportunity to share some ideas or ask some questions at the end of the presentation. A few years ago, I attended a national conference sponsored by an organization called Futures Without Violence. Took a deep dive into protective services and court access. I was a member of a team from Oregon representing WINGS, which is it's a statewide group, the Working Interdisciplinary Network of Guardianship Stakeholders. You can find us at our website, wingsoregon.org, and I would make an additional plug for you to take a look there, a project I've been working on with a small group called the Get a Life Plan, which is a great resource in planning for incapacity and financial incapability. And we've just introduced it out there. We have a Spanish version on our website, trying to get that out there as a resource, not just for all of the people that you're working with in your respective roles or serving, but also for yourself, for all of us. We should all be having a plan in place because incapacity can hit at any time, and we want to make sure that we have things in order to avoid guardianships and conservatorships down the road. So I want to start out by describing the system of care, and Judge has the first slide up there. So Aging, Disability, and Veterans Services Division offers a continuum of services to support older adults and people with disabilities. I'm going to start at the sort of the far right end, which is the protective side of our continuum. Later on, I'll take us back to the far left side of our continuum of services, which will serve as a resource for court staff, hopefully in the future. So to begin with, adult protective services, as I think Judge Henry mentioned, they are engaged in screening and investigation for various types of abuse, physical, sexual, verbal, and emotional neglect, financial exploitation. They do community-based investigations, as well as some types of facilities. And they will also refer to the state for nursing facility investigations, since that function has been moved to the state level. And it's their enhanced screening, I think, that was mentioned earlier. That's the most helpful, is that anyone can call, connect with a live person, share information confidentially, and have them set about their investigative and at least assess and determine initially where the case should land. Within the Department of County Human Services, we have intellectual and developmental disabilities, which serves a different population, and behavioral health, which is actually over in the health department. Each of those respective service programs have their own adult protective services unit, but our unit will make those connections for you and make sure that referral gets to the right program to follow up on investigation. Our APS folks also provide assistance with restraining orders. They have risk workers now that can do a little more in-depth work beyond the conclusion of an investigation to help support some of these vulnerable folks that land, within their purview. And they do all of that, holding an ethical value of self-determination as their guiding principle. The second point there regarding just the MDT approach, the county really takes a multidisciplinary approach in their work with vulnerable adults. So a typical MDT will have a clinical specialist, usually MSW type, a nurse, community health nurse, a mental health specialist, the case manager, if there's typically a case manager involved, if there are services for the individual, and then the APS investigator. And our office also sits in on MDTs once a month for them to staff potentially appropriate cases that might come our way. We also have extensive connections with law enforcement agencies, Portland Police and the Sheriff's Office, and we staff cases monthly with law enforcement and the District Attorney's Office to advocate for investigation, potential diversion opportunities, and prosecution if indicated, typically under the criminal mistreatment statute. The good news in this respect is that we've had a real increase in Medicaid funding, which funds our adult protective service programs. And so I think the manager over there is in the process of hiring about 14 new investigators, which is significant for the county. So we're pleased about that, about the work we're going to be able to do, at least on the investigative side. The downside to our system, after many years of working to get a vulnerable adults unit in place with the Portland Police Bureau, and have specially trained officers and detectives, they have taken a significant hit in terms of budget and reduction in staff. And as you all know, the District Attorney's Office is really having to focus much more on violent crimes and homicides these days. So it's been a little more challenging in that respect, but I'm happy to see what's occurred on the APS side of things. And then as part of the protective service, I like to say that adult protective services can investigate and they can substantiate abuse and neglect and exploitation, but they don't really have the authority within the statute to be able to intervene and keep people safe. They're super creative about how they go about their work, and they do some great work out there in getting folks into safe situations, working with natural supports and all. But my office is in a particularly good place to be able to actually seek court authority to remove folks from dangerous situations and get them the care and supports that they need. So we do a fair amount here in the Public Guardian's Office of information and consultations in the community. We receive calls from lots of social service providers. Hospitals are a big source of our referrals, as people tend to land there when they're in in harm's way and compromised medically and otherwise. Um, we we also get a lot of calls just from the community, work with family members who are struggling with their loved ones who are having problems with diminished capacity. And so we kind of see ourselves as having some expertise in this area of diminished capacity and being able to really focus a lot of our efforts initially on less restrictive alternatives. Not only is that required in the statute, but it's the right way to do this business and to try to keep people as independent and autonomous as possible. So that's one of the things we're doing. It's a big part of our intake process. Generally, our criteria, we serve 18 and over, Multnomah County resident. We're considered a resource of last resort. So no financial resources, no trusted others who are willing and able to serve as the guardian and or conservator. We prioritize abuse and neglect and exploitation, and then what we call extreme self-neglect, where there's risk for life. And we constantly triage people based on risk. There's, as you can imagine, a considerable amount of need out in the community for legally responsible parties, particularly in the long-term care systems, where there's a lot of decision making that is happening more in a informal way with the supports that are available, and so we have to triage. We also, as a result of that, triage primarily on irreversible incapacity. So we don't really have the resource to be able to intervene. For example, if someone has a stroke and then they recover over time. Not to say that we don't have a duty to, if someone has restored capacity, to go back into court, but it doesn't happen very rarely in our cases, just because of the fact that we're screening for that pretty closely up front. In most of the situations we get involved with, the individual is in harm's way, and there's a need for a plan for care and safety, which is essential in carrying out the duties of a guardian. I like to say that guardians sometimes have a lot of authority, but not very much power when it comes to just the day-to-day, because we're working with people who typically have enough capacity to exercise their free will in their daily lives, and that's what makes this work really challenging and important, especially for the protected person. We do most of our legal work in-house. We do have a county attorney, as Judge Henry mentioned, that represents us in court. Otherwise, we spend a fair amount of time doing that. And then we serve as guardian and conservator, which is the real work, right? Up front on the intake part is where the safety and protection comes in. And then you're essentially appointed for the life of the individual, typically. And that's where the real, long haul takes place, with advocating, enhancing personal choice and quality of life for the individual. The people we serve are extremely vulnerable. They've been victimized. They have a history of trauma, complex physical and psychological and behavioral health needs. We serve, across all of these divisions. So we serve people aging and people with disabilities, people who are eligible for intellectual and developmental disabilities, and some people who have really treatment-resistant, chronic and persistent mental illness through the behavioral health system. So folks who are served in that system, we are also involved with. And I think it's important to mention that we take a supported decision-making approach to our work. When I first started doing this, it was all about protection. And now, I think we spend a lot more time and effort, really centering the protected person and considering really bringing their preferences, values, and lifestyle history to the table, and participating in using substituted judgment in our decision-making processes, and then really leaving the best interest standard sort of aside until the person is at risk for significant harm, and then that's where our legal role comes into play. So that whole supported decision-making approach, that's a lot more. We're going to hear a lot more about that in the future. There's a lot of that, again, that happens informally with people with diminished capacity, family members. I'm certain that a number of you have gone through that experience with an older adult in your life. And so I think that's just going to eventually be codified and as an alternative to guardianship. So in our particular role serving vulnerable people, we have the benefit of really in-depth cognitive and functional evaluations, medical information and diagnoses, information about the person's abilities and their communication and behavioral needs. As typically, the individuals are in the hospital or have been in a long-term care setting or have some seen medical providers, and so we have some information that can really help them in this early process where we interface with the court. That's typically through objections and mediation and potentially a hearing. We usually have both lawyers on both sides. We have a judge who understands the population that we're working with, and yet things can still really go awry due to the lack of understanding, confusion, cognitive impairment that the protected person has, and sometimes the impact of the court process in general. Let's see, do we want to go to the next slide?
Sure. Before I do, though, one thing I wanted to mention, Mark, you mentioned that Protective Services is out there. They're doing investigations, they're making findings, but they kind of stop at the water's edge in that they can't overcome people's personal decisions, even if the decisions are unsafe or unhealthy. And I think that's an ongoing challenge, certainly that I had when I was representing you in the county, is addressing the needs of people who are making unsafe and unhealthy decisions, but understanding and respecting their autonomy to do that. When people are willing to cooperate, to be involved with Protective Service, to develop a protective plan for them, Protective Services workers can actually help, can't they, in obtaining, say, a restraining order for a elder, by coming to court with them, making sure that they aren't fearful about taking that step and coming in and seeking the restraining order. Is that still a service that Protective Service provides?
Yes, definitely. And any other, the individuals that they're working with in an investigatory process, any other court-related matters that they might need support with, they can help and do some advocacy. But with restraining orders in particular, yes, they can assist with that process from start to beginning.
Okay.
Okay. So let's see the next slide. So we're going to. Oh, go ahead, Judge.
No, I think this is this will be yours.
Okay.
Mark.
Okay. All right. It came
Talk
back.
about evaluating functioning.
I see it. We're still trying to get this down. Okay. Back to evaluating vulnerable adults functioning. So first of all, I just want, as a disclaimer, I want to acknowledge that measuring an older adult's ability to perform self-care and fulfill important roles in everyday life is typically something that happens in an office or clinic-based setting involving functional assessment and number of standardized tools that are specifically designed to identify issues faced by this population. So what I'm going to provide for you today is going to be some tips and some things to be aware of. We're certainly not talking about in-depth evaluations here, and we want to be cautious of not jumping to conclusions regarding a person's capacity. But unfortunately, court staff really have all of the information that I referred to earlier, or maybe the time or tools or the expertise available to assist with that. But there are some red flags that might indicate more significant impairment and perhaps a need for some follow-up and additional support for the older adult. So I just want to preface by pointing out implicit or unconscious bias, just something we all have to be aware of, our stereotypes that we might have based on ageist and ableism thinking around just the fact that the person is, dependent and incapable and maybe less capable than they might appear. And it's something that, we have to deal with all the time. I was recently out riding I do a lot of cycling. I was out on the 205 bike path, and, I had, I don't know how many, my umpteenth flat that I've been getting lately because of all the glass. And I sensed this unconscious bias slipping in about people who are experiencing homelessness. So, we always have to check that and not engage in sort of othering groups of people. Just something to be aware of. In terms of normal aging, we can talk about the let's see. So normal aging can present itself as varied and multi-directional. So in general, mental processing is going to slow some. Our prospective memory declines, which is really addressing, a failure to perform planned activities. So you might think in terms of things like forgetting to take medications, or, God forbid, forgetting to pick up some anniversary flowers on your way home, things like that. Let's see, and then multitasking can become more difficult. We can have difficulty processing emotionally arousing experiences, and this can be compounded by pre-existing trauma, which we'll talk a little bit about here in a minute. But the good news is it isn't all bad. There are some other areas that we actually improve our functioning as we get older, like our ability to store new vocabulary or new concepts. So that's something that's a good takeaway for us today. When we're getting into impairment where you might start to be more concerned, causing some concern, has to do with kind of the initial thing is, we have to do kind of a full evaluation with our senses, just the appearance and the presentation of the individual. If someone is presenting with real severe confusion, that can be a warning sign, indication. Judge Henry referenced the medical vulnerabilities. So we have to think about the myriad of underlying medical conditions that can cause reduced functioning at any time. Common ones, urinary tract infections. We see those all the time with older adults. If someone has breathing difficulties like congestive chronic obstructive pulmonary disease, that can cause extreme anxiety, blood pressure, and then for people who have diabetes, their low blood sugars can really contribute to them representing themselves as or appearing to be much more confused, having difficulty with attention, and impact their participation. We also want to think about chronic pain and the effect that the pain can have on cognitive function. Folks are on a number of medications, so medication interactions are always something to be mindful of, as well as metabolic imbalances. If any of you have ever, become dehydrated, severely dehydrated, your electrolytes are off, you can, you can become very impaired very quickly. And it's something completely reversible, but it can, it can appear as though the person is more impaired than they actually are. These days, we always have to be aware of the effects of drugs and alcohol, the stress that just comes from particularly entering a courthouse and being involved in a proceeding can be very stressful, and it can it can have a double effect with pre-existing trauma. We also see a lot of folks with just delirium, people coming in and out of the hospitals. Delirium can develop due to underlying medical conditions. They're usually temporary, but they can lead to disorientation and memory and confusion. And all of these can result in reduced cognition and really mask as diminished capacity. When you're, maybe I backed up on that one.
I will point out that one of the last points on this slide that I'm going to skip over is that as Mark is describing people's challenges in terms of their cognitive functioning, causes of the challenges, we're meeting people at a moment in time. One of the things I indicated at the bottom of the slide is a concept for judges to consider has to do with appointing a guardian ad litem. That's going to have to be a whole other conversation, and we really are short on time now. It is not, I will say, a particularly good solution in very many cases, but it's something that is a potential tool to appoint someone to assist with the particular piece of litigation. But I think we should move.
We can go. Yeah, we can move along. You bet. To the next. So if you're, okay.
And the other sort of side of this, Mark, is describing how you're evaluating somebody who's coming to the courtroom, is coming to the front desk or an area of the courthouse, and you're having some concerns with some signs of their challenges in terms of their functioning. There are other tells that maybe should have our antenna going up. If there are support people who are accompanying a frail elderly person to the courthouse, you might be keep an eye out for some things that may come to light in your interaction with these support people that you may learn in this courthouse interaction relating to the financial dependence of these others who are accompanying the elderly person, their financial dependence on the elder, that they have a shared housing arrangement, which makes the elder particularly vulnerable. If there's the people who are presenting with the elder person have some indications of their own substance abuse or mental illness, you probably aren't going to have access to information regarding a history of abuse or neglect, but to the extent that is in Odyssey or in a case file, that would be helpful information. And your view of the elder who's being accompanied by support people or caregivers, but the elder doesn't have critical devices like eyeglasses, like hearing aids, they're appearing with poor hygiene. If you've got people who are sort of overbearing or stepping in between you and the elder or trying to interact as you're trying to interact with the elder person, and if there's a presentation of the affect of your elder is fearful, is withdrawn, all of those are signs that perhaps there's something going on that may take another step from your part to assist the elder person. And that's what Mark is going to address here.
Yeah, so if you have concerns about that person's functioning, their general condition, and they may need additional information regarding services, back to the front end of our continuum of services here, we have the Aging Disability Resource Connection, and there's a phone number there. They will anonymous and confidential, take calls from you. I also have we have cards with the phone numbers in a number of languages that I'll deliver to Judge Henry, so that you'll have those available to hand out for people. And this is part of our role as the Area Agency on Aging, and where we administer Medicaid-funded services along with a number of other community resources that are listed there that people might need assistance with. And I'll just mention that these people who are answering these calls, they have connections through all of our systems, our siloed systems of aging people, disabilities, intellectual and developmental disabilities, and behavioral health. And they can connect them. They can make a call to the individuals who are involved, the case managers, the coordinators, the mental health therapists, and other wraparound services that are involved, and let them know that this person might need some additional support, or let the program know, or the individual can call themselves and report that. So that's a big resource that I think can be helpful to the courts in looking to community partners for some support in these situations. Next slide. So I'm going to move a little more quickly through this. We're running short on time, but so the ideas here are really to focus on be person-centered and effective in your communication. A lot of this I like to think of as just the approach should emphasize safety, trust, and belonging for the individual who's there. Seeking appropriate and authentic connection, using inquiry for better understanding the individual's needs. I like to ask people to help me understand, help me understand what you're going through, help me understand what you need from me right now. And then, just double dose of compassion on top of that. So effective communication to reduce barriers. Understanding that, some support people you might have to have some concerns about, but generally they can be really helpful in assisting you with the individual. There's a model bill of rights for older adults, and one of the rights on there is the right to be accompanied by an aide, a nurse, or other support person. So that can be helpful to you. Establishing eye contact at their level. Speak slowly, clearly, plain language. Recheck for understanding and clarification with the older adult or the vulnerable person. Ask them about their preferences and when they're at their best, what they might need if they need to take a break, and try not to assume that people can read instructions. We're real good as agencies of handing out things to people, so sometimes we may need to assist them verbally as well. And then maintain some flexibility and sensitivity to their needs. Some of the things that we've talked about there earlier. Also from the Bill of Rights, a reasonable wait time is something that older adults should be granted. Okay, next slide. I'll just mention at the end of that, just consider virtual appearances. Those have worked really well for us and for our clients. They can have a support person on their end. We can take some time. They're in their own environment, much more calming. And I think that's been a huge improvement with COVID and everyone going to virtual mediums, and could be a real benefit in the future.
There does sound like there's a practical piece there, Mark, in terms of how we're running the courtroom, we judges, in terms of considering, how are we going to allow a person who needs support be supported, physically, have somebody close by. We have sort of strict rules about who's allowed in front of the bar, and maybe some flexibility about that in terms of how we're allowing someone to be supported. So this last slide has to do with the trauma-informed approach. Some really good information. I think it's an important thing to consider. We are out of time. Let me just summarize in terms of what we have been trying to achieve for now a number of years in the courthouse. In terms of procedural justice, when Mark is talking about how we communicate, level of compassion and connection that we make with people, I think those are absolutely essential with people who are self-represented, who have very important things that they want to achieve, and they're dealing with a high degree of trauma and conflict that they've been through. What do we want to make sure? We want to make sure that their voice is heard, that they feel as if they've had an opportunity to be fully heard. That may involve us slowing down and allowing people to actually tell their story, as difficult and challenging as that may be with our full dockets. We want people to be treated with respect. That's part of what we're going to achieve if we address people and see people not as categories, but as individuals with their own stories and their own struggles. We want to make sure they understand that we're neutrals. We're not here to take a side, one or the other, but we're here to address whatever the issue is and to apply the law neutrally to all the participants. And we want to do everything we can to help people understand why we're doing what we're doing. All of those things are things that we need to be working on through this lens of dealing with people who are now potentially struggling with their own cognition and their own ability to understand. Again, it may take us a need for us to slow down, to quiet down, and to let this a person have the opportunity to be fully heard. Judge Long, we are at time. Is there, unfortunately, I don't have the chat function turned on. Are there questions that you see that you would like to have us address briefly, or we want to just excuse people and tell them to go on and do
I didn't see
good?
any that specifically came through, although certainly if there's anybody who wants to ask anything real quick, they're welcome to. I want to thank our speakers very much so. And also, as always, remind everyone that in the chat, Roger has posted the feedback survey, and we really do ask that everyone fill that out if they have a quick minute. It's personalized to this, and it's very important to make sure that we get feedback both for our presenters and for our committee. And I thank you both so much. And actually, I do see a quick question. If you have someone in court who's obviously mentally ill and is trying to get the court to do something it cannot, what do they do? What is your advice?
Well, I mean, I'm not quite sure if you know, if a person is asking of something that we can't do, we just have to explain that we can't do it. I mean, it may be evaluating, as Mark was saying. Mark may have a better answer on this than I do, but if we're listening really carefully about what the person is asking for, I mean, the possibility is that a person can be directed to one of the programs at the county to receive additional services, to get supports, even though the court can't order someone to do a particular thing. We just aren't authorized under the law to do a specific thing that's being asked of us. To the extent we're hearing carefully and listening carefully, there may be some place that we can send them to receive a service to help them get a support that may not be the specific thing they're asking for, but maybe some help.
Okay.
Well,
I see several folks saying how helpful this has been, and it has been amazing information. And certainly folks would love to get a copy of the presentation slides and materials. So we'll ask Roger about whether or not we can share those. And in the meantime, it's 1:03, and I know folks need to get moving on for their presentation. So we'll make sure to get that out. Again, please, everyone, take a minute to fill out the survey if you have a moment. And thank you so much to both of our presenters. This was fantastic. We really appreciate it. Thank you.
thank you, Judge.